Hi guys, so I'm working on my moot court brief and I thought it'd be a good idea to maybe give you an overview of the case and then show you how I'm going about working on that brief. Now for those of you that don't know, moot court is essentially a fake case. So the school assigns us a hypothetical case based on a real case, and we have to write the briefs and argue it in front of a hypothetical court and hope to win the case. So what this case is about is the U.S. Fish and Wildlife Service listing a species as endangered and then designating critical habitat for that species. So when the Fish and Wildlife Service determines that a species is endangered or threatened, they're required to designate critical habitat. And critical habitat is any area that is essential for the survival of the species. And when they designate an area as critical habitat, especially if it's private land and not already government land, the value of that land goes down significantly because it prevents a lot of different scenarios where you'd want to build or develop that land, which in a lot of cases is a good thing. We need to protect species. We need animals that are on this planet to stay on this planet. Humans shouldn't be the reason for their extermination. Now, the animal at issue in this case, Weyerhaeuser versus the U.S. Fish and Wildlife Service, is the Dusky Gopher frog, which is a little frog, spotted and warty frog that lives in southern Mississippi. When they get scared or threatened, they'll pop their back legs up in front of their eyes, which is kind of cool. And they basically live underground for the vast majority of their life, unless it's raining. Unless when it rains in the spring, they travel from these forests down to a pond where they breed and lay their eggs, and then travel back and go back underground up in the highlands of the forest in southern Mississippi. And so what happened here is in 2001, the U.S. Fish and Wildlife Service determined that the Dusky Gopher frog was endangered. But they didn't list critical habitat because at the time they didn't have the financial resources to devote time to figuring out which areas of Mississippi or the surrounding area were essential for the survival of the species. So what they did was list it as endangered and then kind of hands off, didn't touch it again until 2008, where they were sued by various environmental groups saying you need to designate critical habitat for this species because there was only one population, one area where these frogs lived, and there was only 100 frogs left in the entire country, the entire world really. And so the species said, the Fish and Wildlife Service said, okay, we'll designate critical habitat. So in 2006, they published a proposed rule designating certain areas in Mississippi as critical habitat for the Dusky Gopher frog. And they said, we'll accept comments on this rule, the proposed rule, until 2010. So everybody send us your comments, let us know what you think. A lot of times that's environmental groups or private landowners whose land is proposed to be critical habitat. And essentially, for that entire comment period, the Fish and Wildlife Service was working on this, looking at comments, especially comments from scientists. They're required to get three expert scientist opinions on the matter, and then a lot of other scientists and environmental groups pitch in these comments. So the Fish and Wildlife Service is looking at these comments. The comment period ends in 2010, or is supposed to end in 2010. Well, in 2011, after the comment period has ended, they put out a new proposed rule. And this proposed rule said that we're not only sticking to areas in Mississippi where the frog has historically been or even recently been, but been pushed out. We're going to add this one area way over here in Louisiana that really isn't connected to the other ones. The only reason that they added that area in Louisiana is that was the last place that frogs were seen in Louisiana in 1967. And haven't been there since. And so they added this little area in Louisiana and then gave the public 1 month to comment. So for the prior rule, all the places in Mississippi, they had 4 years to comment and tell the Fish and Wildlife Service what they thought of this designation as critical habitat. The landowners in Louisiana, my client, they only had 1 month. And that's not necessarily the issue. The agency can make the comment period however long they want, as long as it's reasonable, and a month to the courts is reasonable. So lawyers before I got this hypothetical case sued the Fish and Wildlife Service on a number of grounds, saying that this is unfair, that they shouldn't be able to designate this as habitat for the frogs, because guess what? The frogs need a certain type of tree, longleaf pines that are spaced out and they only have leaves up at the top, or I guess pine needles up at the top, so that there's an open canopy floor. The frogs, when there's a covered canopy, the forest floor gets a little too vegetation-y, so they can't burrow and can't live there. And so they said, and the land that was designated as critical habitat in Louisiana, my client's land, was essentially forest plantation land. They had cut down all the longleaf trees that used to be there and planted new trees to be harvested, economically and sustainably for lumber. And so they said, the previous lawyers argued to the court, well, how can this be critical habitat when it's not even habitat? In its current state, the frogs couldn't live there. And what the service said was, well, with reasonable modifications, the frogs could live there. But here's the problem with that. Even if they wanted to modify the land, the private landowners still owned this land. The government wasn't going to force them to sell the land, essentially. They were just saying that you can't do anything to this land for the next who knows how many years, because frogs could potentially live there if we cut down all your forestry trees and planted new trees and added certain features to the landscape so that the frogs could survive there. And the landowners didn't think that was right, and personally, I don't either. And so what happened is the Fish and Wildlife Service won in the district court, the first court where they sued. And the landowners appealed to the Fifth Circuit Court, the appellate court. And at the appellate court, the court essentially agreed with the district court, and they said, no, the Fish and Wildlife Service was completely within their authority there. They had the power to designate this as critical habitat. Well, two of the main arguments that the landowners used at this stage was that, one, this can't be critical habitat because it's not even habitat. And two, even if it was critical habitat, there are certain standards that the agency has to use when determining whether to exclude private areas from critical habitat. They have to look at the economic impact of this. And what the landowners were saying is that we plan to develop this land. After we cut down all the trees, we were going to make this into an urban development, essentially. And the Forest Service robbed us of the ability to do that because they wouldn't be able to get the permits to build there in the future, which is millions and millions of dollars of impact for an area where the frogs, again, couldn't even live. And the appellate court, the Fifth Circuit, said, we don't care. We agree with the lower court. We're siding with the Fish and Wildlife Service. So the landowners appealed to the Supreme Court, and now it's extremely rare for a case that's appealed to the Supreme Court to be heard by the Supreme Court. It's a very small percentage of people that ask to get in front of the Supreme Court that actually do. And the Supreme Court thought that they had a good enough case that we will hear their argument. So they got to the Supreme Court, and the Supreme Court took issue with two parts of the appellate court's decision. One, they said that critical habitat definitely had to be habitat. By nature of the two words, critical is an adjective describing the habitat. There must be habitat for it to be critical habitat, which is a common sense thing, but the Fish and Wildlife Service actually argued in the Fifth Circuit and in the district court that critical habitat does not have to be habitat, which is an outlandish argument. And they won on that argument. But anyway, the Supreme Court said, no, it has to be habitat. The issue is we don't know what habitat means in the statute. Now, habitat has a pretty generally commonly accepted meaning, which is like where an animal lives, but the statute works in a way that common definition doesn't necessarily work, because the service can designate unoccupied areas where they could live but don't as critical habitat. So that's included in habitat. So essentially they said, okay, on this issue, it's going back to the Fifth Circuit, and they need to decide what the word habitat in the statute means. The other thing the Supreme Court didn't like was that the Fifth Circuit didn't even consider the economic balancing test that the Fish and Wildlife Service was required to go through. They said, that's completely up to the service's discretion. We have no standard to judge whether they were right or wrong. These are a bunch of environmental experts, so we're just not even going to touch it. And the Supreme Court said, no, that's wrong. You need to examine their decision and make sure that they made the decision in the way that Congress, that the people that America voted into office, told them to make the decision. They need to follow the factors and do this economic balancing test correctly. And so that's how we got here. I am now representing my client, the Weyerhaeuser landowner group, against the Fish and Wildlife Service in the Fifth Circuit after we got back from an appeal to the Supreme Court. So now I'm working on the brief for our second time in front of the Fifth Circuit Appellate Court. And I'm still in the early stages of the brief, so I'm doing the statement of the case, which is essentially an overview for the court of the statutory framework that we're working with, the law at issue, the decision that the Fish and Wildlife Service made, the things that went into that decision, the process of how we got here, the different rules and proposed rules and final rules and comments, and that sort of thing. And this brief is a long process. I'll be working on this throughout the entire year. So right now I'm just working on that statement of the case. But to work on the statement of the case, you have to cite facts in the administrative record or cite pages and volume numbers of the administrative record. And so what I've got right here is the original listing decision. So back in 2001, when they decided to list the habitat as critical habitat. And so how I went through this is on this record log, I call it. I basically set up a system where I put the page number, so 62993 right there, the actual, and that's the page number in the Federal Register where agencies do all of their rulemaking. And then I put the actual page number, so page 1, column 1, and I give it a quick description of the support. So whether this helps my case, is neutral, hurts my case, whether it's a question I have or something along those lines. And then I give it a title and a description. A lot of the time for the description, I'll just copy and paste what it is. And sometimes for the description, I'll give a brief, overview so I can go back and look at the record if I really want to later. And the reason I do this is so that when I'm writing this brief, I can just look at this Excel sheet and decide, okay, that's a good quote, I want to include that, or decide, oh, that really supports my argument here, I'll include that, and I have the citation ready, so I don't have to go back to the brief and figure out what page was this on, or go back to the decision and figure out what page is this on, so on and so forth. And so this will make it really easy when I'm writing the brief. It's a lot of work up front, but it'll pay off in the long run. So I did it for the listing decision, original listing decision in 2001. I did it for the first proposed rule in 2010. I did it for the revised proposed rule in 2011, and that's when my client's land got included, looped into this. And essentially, I have some pretty, I was working on this late last night, so I have some funny notes. The motherfuckers took out the word habitat from all of these conclusions. But essentially, what I think happened is the Fish and Wildlife Service decided, okay, we need to include more land, but we don't really have a justification for including this land over in Louisiana because we know that it's not habitat. So essentially what they did was Command F, they searched their entire old rule and took out every use of the word habitat so that they weren't implying that the land in Louisiana wasn't habitat. Well, that's not really something you can do, so that's definitely going to be a big argument point in my brief and when I get to oral argument. And another thing I did while I'm going through this revised proposed rule is I use this online source. It's diffchecker.com. And essentially I put the two documents in there and it puts them side by side and shows me what's different from the original rule to the proposed rule. And that's helpful for obvious reasons. It's just easier to go through and see what's different, so I'm not rereading the same stuff over and over again. And it's pretty striking, some of the things that they added and left out. They were clearly they anticipated that this was going to be an issue, and they were clearly trying to manipulate the record to support them naming this random area in Louisiana as critical habitat. Now I'll keep you updated on this as I'm working on it, and hopefully bring you along with my moot court case this year. Thanks, guys.